Hey guys, this is Thiru Parmar back with the series where we are discussing topics or question with solution related to fundamental rights, which is previously asked in UPSC mains CSE exam from the year 1979 till the year 2016. So today we are going to discuss about this particular question, which is asked in the year 1998 paper 1 question 7a. So basically it is asked for less marks, that is for 6 marks only, but we are going to relate the same question with the help of a current affairs. So we can actually understand how to basically how to relate these questions with current affairs and which type of current affairs we can add in which type of answers. So I'll just read out this question. What were the circumstances leading to promulgation, or we can say government always used to promote or emphasizing more and more of Prasar Bharati ordinance? So government has passed one ordinance. Remember, this is an ordinance, not any amendment or not any rule. So it is just a temporary some ordinance which is passed by president. So here, as you can see, promulgation of All India Radio, or we can say Prasar Bharati. So what is this case all about? That the promulgation of Prasar Bharati ordinance to provide autonomy to All India Radio or Prasar Bharati. So as you can see, government declared it was aimed to expand the sphere of Prasar Bharati, and same thing where again there are allegation from the opposition that government is increase the government's influence over Prasar Bharati and a few other things. So we basically don't care with this particular point, and we totally don't care with the last point. We just need to concentrate on first 2 points where they have where I have written about Prasar Bharati and what is this ordinance all about, and what is political debate which was going in that year. So we are not concerned with that. But what we are concerned with, that till today, in today's time also, government allows All India Radio or Prasar Bharati to broadcast the news, but they are not allowing FM stations to broadcast the news. As you can see, this is a current affair based article. So why can't FM station broadcast news? Ask Supreme Court. So radio is accessible to everybody. Most of people uses FM radio, not All India Radio. There are very few people who basically listen news and other programs on All India Radio. So most of people goes to FM radios only for traffic update or for any other kinds of updates. So as you can see, traffic update is also one kind of a news only. So as you can see, the NGO in its petition challenged the validity of a policy guidelines and grant of permission agreement framed by a center, saying that while these norms allow broadcasting of information including news on sports, for example, we might get a status of India versus some Pakistan or World Cup or IPL matches status on FM radios. Also we can get update about traffic, also we get update about weather and many other things. So if we are getting information, all the latest information about all these things, then why can't we get the information about current affairs as well, or political news especially, what we say. So government is not allowing FM radio stations to broadcast this type of news, which is only applicable or which is only permissible on All India Radio. So this is the current debate. As you can see, in the year 1998, government passed one ordinance, president passed one ordinance, and still that type of mentality is still going on in our government. So I don't know what's wrong with that. But as you can see, fundamental rights. So if we are restricting someone, for example, in this case, we are restricting FM radio station. So as per the fundamental right part 3, which is considered to be as a magna carta of our constitution. So as you can see, fundamental right of freedom of speech and expression is guaranteed under article 19(1)(a), article 19(1)(a) of the constitution. So we or Supreme Court or any authority in our country, they cannot restrict one's fundamental right without any proper situation. For example, this fundamental rights, they can restrict fundamental rights only in a situation like emergency situation, financial crisis, or such situations as we have already read in past lectures. So read right to freedom of speech and expression also included right to information, which encompasses diverse interpretation of news and current affairs. So basically what government says that there might be a diverse interpretation. One might uh, 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 broadcast view of some politician in some other way. One might broadcast the same view in some different way. For example, in case of OAC, some MLA from Hyderabad. So a few of the news channel, they broadcasted that OAC is not ready to say Bharat Mata ki jai. So those particular news channel broadcasted their view in totally manner which describes that personality which is not in favor of India, or in simple words, OAC is not patriotic, or patriotism is not there in OAC. So as per few news channels, but at the same time, there are few news channel or few newspaper who basically provided the same information in much better way. It means we cannot define any person whether his love for his nation. We cannot define one person's love for his nation based on some slogans, right? So based on slogan, if someone says Bharat Mata ki jai and he is actually involved in some anti-national activities, so it doesn't mean that if he says or if he's accepting the slogan, that means he's totally patriotic. And if someone is denying some kind of slogans, that means he's not patriotic, right? So same news, sometimes interpretation might be different. Always this happens. Now let's go back to next. Let's discuss the next question. In this particular question, we are going to discuss state the amplitude of Article 21 of the Constitution. Now remember, before UPSC used to ask direct questions about articles. In today's time, UPSC do not ask such question. They basically give you some questions. For example, Santara case, if you might heard about it in news, that is Jain rituals, it is related with it. So they might ask you on that and many other current affair based questions. So state the amplitude. So we'll just discuss Article 21. Now this particular part will help you in mains as well as in prelim part as well. And we'll discuss a few of the current affair questions as well, and few cases where you can actually use this particular part. So let's just start with this. So what Article 21 states that life, protection of life and personal liberty. Now remember, it is one of the fundamental right which cannot be denied under external aggression or under any warlike situation. As we know that few of the fundamental rights, government can put restriction under warlike or external aggression kind of situation or financial crisis. Government can put hold on few of the fundamental rights, except at fundamental right article number 20 and 21. Government cannot restrict this particular fundamental rights under any XYZ situation. So this is one of that particular fundamental rights, the most powerful one of the fundamental right in Indian Constitution. Life, protection of life and personal liberty. It is available to any person, not just Indian citizen. Remember this, it is also available to foreign nationalists who basically travel in India, who basically works in India. Any foreign delegates who comes to India, any diplomat who visits to India. So it is basically responsibility of India to give protection to them. Why? Because Article 21 provides protection of life and personal liberty. Its amplitude has been enlarged to include, now we have also included rights to privacy, education, pollution-free environment, and rights against exploitation, bondage, laborer, etc. Now remember, if you ever find that any activity from government side violates your fundamental right, that is Article 21, one can directly approach to Supreme Court. This is the one of the biggest power. not in any other case we don't have right directly approach to Supreme Court except when our fundamental rights violated, and that is also case in Article 21. If Article 21 violates, one can directly file a case directly in a Supreme Court. As we know the proper procedure, that if we find that any violation goes on, we first need to file a case in district court, then high court, and then comes Supreme Court. But in violation of Article 21, one can directly file case in Supreme Court. So now let's discuss Article 21 and related issues. We'll discuss few of the cases here. Right to life and personal liberty. Let's discuss few of the cases which we can use in our answer as well. So first is capital punishment. Capital punishment means death sentence. Now many countries abolished this particular punishment, but India is among the few of country who still follow this particular process. So we have made many changes under few of the cases. We'll discuss those cases. For example, in Bachchan Singh case in 1980, Supreme Court pronounced rarest of rare doctrine for capital punishment. What it states that rarest of the rare means we cannot give capital punishment or death sentence in all the cases except if a person violated all the humanitarian lines. For example, in case of Nirbhaya gang rape, Delhi case 2012, where Supreme Court officially gave capital punishment or death sentence to 3 of the rapists. One was juvenile. So except that juvenile, all the rapists got capital punishment, that is death sentence. Why? Because they not only just raped that girl, but also they made some very they behave in very cruel way. So hence that is considered to be rarest of the rare case. As you can see, in this case, that is Bachchan Singh versus State of Punjab, the Supreme Court laid down rarest of the rare doctrine and held that capital punishment should only be awarded in rarest of rare case. Just remember this. Now next is Machli Singh case in 1983, where Supreme Court gave guidelines to be when life imprisonment appears inadequate. So sometime it might possible that some person involved in many much cruel crime, so that time life imprisonment if not adequate, then we can go for capital punishment as well. Then in Rupa Hurra versus Ashok Hurra case 2002, Supreme Court introduced curative petition. Now remember, we have till before 2002 we were only known about review petition. Review petition means if we are not satisfied by the decision given by Supreme Court, then we can review their decision with the help of review petition. This is the last step. But after this Supreme Court also introduced something which is called as curative petition. So if after review petition, if you still find that judgment given by a Supreme Court is not up to the mark, then you can officially go for curative petition. Now what we mean by curative petition? Curative petition, the petitioner to establish that there was a genuine violation of principle of natural justice. Remember, if violation of principle of natural justice and that the bias of the judge adversely affected the case, to ensure that is no miscarriage of justice and to prevent abuse of process usually decided by judges. So if something that principle of natural justice is not there, if it is missing, then one can officially go for curative petition, and this is what we mean by this. I hope it is clear. Now next is in Shatrughan Chauhan case 2014, where Supreme Court said that in case of extraordinary delay in disposing of mercy petition basically one can file to President. Then the same way the trend is move from retributive justice. Retributive means the trend is to move from retributive justice, that is eye for an eye, to reformative justice, means give everyone one chance to turn over their life, or one chance to start a new life in a better way. So we'll just discuss the same topic in next class as well. Thank you.